the Am I audible?
Yes, you can start now.
Today I am here to give introduction of our today's chief guest, Advocate Prosper D'Souza sir. First upon all, I welcome to all the today chief guest, Advocate Prosper D'Souza sir, all the members and vice chairman and vice chairman of Bar Council of Maharashtra and Goa, all the members of Bar Council of Maharashtra and Goa, and last all the participants who has participated in this lecture series. Now I introduce to today's chief guest, Advocate Prosper D'Souza sir. Sir is having qualification of BA LLM, Diploma in Labor Law, Diploma in Cyber Law, practice of 24 years of advocacy, and sir is having 20 years of uh, teaching experience. Sir is also have appointed as arbitrator and mediator at the panel of Bombay High Court. Sir is also authorized two books. One is on TP and another one is an SRA. Advocate Prosper D'Souza sir will enlighten us on topic of Parsi marriage and divorce law for today. I will over it to D'Souza sir.
Thank you very much, madam. Thank you. And once again, I have to thank you, Sonali Chavan, madam. I have to once again thank Chairman, Advocate Vivekanand Gadgeji, Advocate Dr. Uday Varunjikar, Vice Chairman, also Advocate Jain Jaibave, and all the other members, right from your Advocate Moti Singh G. Mota to Advocate Amol S. Savan. Not to say that Moti Singh is inferior and the last one is a superior or the other way around, whatever. But I wish to thank each one of the members, the Bar Council, as well as the staff members who have made it possible for the lecture series to happen. So this few things I would like to make a beginning on this law. The task which is assigned to me is this Parsi law of marriage and divorce. Okay, it is 1936 law. There's a little background to it, little history to it. There are a few dates. I don't think anything has ever been asked in the past about dates and all that, but just in the passing. Okay, it seems efforts were made somewhere way back in 1865, no, to have some kind of law suitable to the social requirements of this Parsi community as such. But those efforts proved abortive. Nothing came out of it. Nothing happened. Ultimately, in 1855, the Parsi Law Association that was set up for the purpose of drafting special bills for law applicable to Parsi community. And that bill was supposed to cover marriage and divorce. And the act was passed as a result of this Parsi Law Association. And the first law which came into being was Parsi Marriage and Divorce Act, Act 15 of 1865. So 1835, nothing really happened. 1855, Parsi Law Association that was set up, and then a law came into being in the year 1865. Now, this Parsi Marriage and Divorce Act, 1865, that was based on the Matrimonial Causes Act, 1858 of England. You know? As time went by, the circumstances changed. There was a need felt to update this law. First, it was discovered that there were certain loopholes in the 1865 laws, especially with regard to the divorce thing, adultery or adultery coupled with some matrimonial offenses. They were the only grounds available for divorce under the Act. And only a wife could seek divorce, judicial separation rather, on the ground of cruelty. On the ground that the husband has brought a prostitute in the house, that could be another. On the other hand, his husband had no relief by way of judicial separation. That was the state of affairs in the year 1865 and a few years thereafter. And this shortcomings were to be, something was required to be done about it. And right enough to keep in conformity with the those days current condition, those times conditions, this Parsi Marriage and Divorce Act 1936 was enacted. That was done in order to update, in order to be in tune with those times as such. Okay. Now this Parsi Marriage and Divorce Amendment Act came about in the year 1988. Whenever there are amendments, it's once again to bring in some changes. And these amendments were carried out to section 3, 6, 19, 20, and so on. There are quite a few sections which were amended in the year 1988. Not only 1988 brought about in its fold some amendments, but also some sections were introduced or rather inserted in the year 1988. Those were 32 double B, 32 double D, 32 capital A, capital B, and also there were some sections which were substituted. Those sections were 38, 39, 40, 43 in this very 1936 Act. And this Act came into force, this amendment came into force on 15th April 1988. Notification was brought about on 12th April as said, okay, in the Gazette. Now, also we have seen there was an amendment in the year 2001 as well, where section 39 and 49 were amended. So if you go to say right from 1865 when efforts were not successful, right up to 2001, there were a number of ever since this first law came into being 1936, there were numerous amendments which were 1865 rather, and thereafter other laws came into being, other amendments came into being. And finally, we have this latest version with these amendments carried out in the year 2001. Moving further, as usual, like any other law, this law will have an introduction or rather the preamble, not introduction, preamble. And this the preamble would tell you that it is to amend the law relating to marriage and divorce among Parsis as such. This law, like few other laws, is not codifying act. It is there to amend the law which existed prior to this. Okay. So what does it do? It amends and it repeals that earlier law, 1865. This law, as we said earlier, this law was based on English law of marriage, the Matrimonial Causes Act, 1858. As we go along, we will see the differences between this law and few other laws when we do some kind of comparison in the passing. Now, we have already commented because the earlier laws did not meet the needs of those times, the changing times, and that Parsi Central Association appointed a it was required to appoint a subcommittee as well, which I have not said earlier in the year 1923. And certain amendments were suggested with the approval of some personalities like retired Honorable Sir D.F. Mullaji and Sir Dinshaw Vachaji. I felt of mentioning this name because due credits have to be given to these people who have made valuable suggestions with regard to certain amendments. I will move on straight away to the section. Section 1, as usual in so many other laws, this law as well, talk about the name of the law, which is the Parsi Marriage and Divorce Act. So unlike the Christian, you have separate divorce law and separate marriage act. Here it's both marriage as well as divorce in one very law itself. So this is 1936 law. Then we know that it extends to the whole of India. Earlier it was except state of Jammu and Kashmir. Ever since that Jammu and Kashmir Reorganization Removal of Difficulties Order 2019 was issued by the Ministry of Home Affairs and a notification brought about on 30/10/2019. This has been extended to Jammu and Kashmir as well. So now this law is applicable from 31st October 2019 to the Union Territory and this Jammu and Kashmir Union Territory of Ladakh as well as Jammu and Kashmir as well. No? And as we go further, you'll see that there's a proviso to this section 1, which, or rather, section 1 is only the title. Section 2 is about the applicability, extends all of India, and what I just said. Then there's a proviso to this section 2. In fact, there are two provisos. One, it will talk about the central government. It is given the power. So, in respect of territories which immediately before the 1st November 1956 were comprised in Part B states by notification in the Gazette, central government can direct that the provisions of this act relating to the constitution and the powers of Parsi matrimonial courts and to appeals from the decisions and orders of such courts, they would apply with such modification as may be specified in the notification. Central government is given this power. What are Part B states? There are states like Patiala and East Punjab, okay, and Pepsu. Pepsu is states union. Then you have Hyderabad, Jammu and Kashmir, Travancore, Cochin, Madhya Bharat, Mysore, Rajasthan, and Saurashtra. Then you go on to the second proviso. You talk about this. It says, for provided further that nothing contained in this act shall apply to the reconcants of the Union Territory of Pondicherry. Reconcants. No? The persons who adopted, or rather, sorry, who opted to be governed by French code while this Pondicherry was under French occupation. That is the meaning of this reconcants as such. Then you have 3, which talks about when it comes into force. It comes into force on 22nd of June 1936. By notification, it has been brought into force. Then there are certain definitions as such in the definition clause, which is section 2. That was section 1 and subsection 2 and subsection 3. Now, rather, we are on subsection 2, which is about definitions. So, that usual line in this act, unless there is anything repugnant in the subject of under. Repugnant means contrary, not inconsistent with, not in keeping with. Then you have few definitions given out there, Chief Justice and court, and what it means to desert. Okay, the definitions out there on your bare act also you will find them. Okay, desert without reasonable cause and without the consent or against the will of that party. Somebody goes, no, so or other leaves that person, then that would amount to deserting as such, no? Deserting the other party to a marriage. There is no reasonable cause without the consent against the will of that other party. Then you have the definition of grievous hurt. I'll be making a few comments on all of this. Then you have definition of husband. Then marriage, whether it be contracted before this act came into being or afterwards, so retrospective as well as prospective. Now, moving on to a little more on the definition. We have the definitions of court given here. Okay. Court, when we spoke about in the passing, we said court, we did not actually say what court means. Definition wise, it says court means a court constituted under this act. But that is not enough for our understanding of this act as such. We have to understand a little more about this. No? This word court is, they say, promiscuously, promiscuously used throughout the act. It's used in a number of places. No? So therefore, it must be read in its context in order to determine what? Whether court would mean only the judge or the delegates as well, no? Or the judge sitting alone. So that, and the answer as you go along will see in number of sections is that it would mean judge alone, be it section 25, subsection 3. There also the word court comes in. So, which grants the leave to sue after recording its reasons in writing and all of that. You'll see there also they want us to know that the court would mean a judge alone. Then when you move on to section 33, I'm saying all this because anyways we are going to touch upon those sections as we go along. But the idea is to tell you that whether it judge to be is to be considered a judge alone or with the delegates or he alone when he sits alone. That is what we are trying to understand and as given in the various sections. Then you move on to 33. There also you will find the answer is court. So court would mean again judge alone there also. No? So then it is about 33 about, it says it is provided every suit for divorce on the ground of adultery, the plaintiff shall, unless the court shall otherwise order, make the person with whom the adultery is alleged to have been committed a co-defendant. Now, what do you mean by court there? It means the judge alone. Then again in section 35E, it's about a decree in a suit under section 30, 31, 32 or 34. Cannot be pronounced unless the court is inter alia satisfied that there is no legal ground why relief should not be granted. There again, you will see it's the judge alone to determine and the word court is used. When you go to 39 also where it is about, it refers to an application pending lite. Pending lite is pending litigation by the wife made in a suit under this act. Then interlocutory applications also, they are dealt with by the judge alone. Again, move on to 40 also, there also what would mean judge alone. When the phrase used there is by the satisfaction of the court. What do we mean by satisfaction of the court? Court would mean it is judge alone. It did not intend to include within its fold the delegates as well. Then you move on to section 47, where an appeal lie, amongst other things, where the decision of the court is contrary to law or usage. No? So there also it's judge alone. Because they say if the word court would include delegates, it would mean that the decision of the delegates also be contrary to law. No? Whereas question of law are outside the purview of the delegates. Therefore, there also court would mean judge alone. Then you have section 52 also. Court may allow proceedings to be amended if necessary. There also the understanding is judge alone. Moving on to another definition, desert. Desert would mean without reasonable cause, without the consent or against the will of the other party that we have already seen in 2.3. Then we there is a definition of grievous hurt, and few things as in your IPC are given there what grievous hurt means. Right from emasculation to any hurt which endangers life, all of those things are given there. So it's from A to G. But there is a slight difference there. So definition of grievous hurt given in this act, this Parsi Act, I'll call it Parsi Act for short in brevity. So it's almost the same, you could say, as given in 320 of the Indian Penal Code. But there are two differences. One is, apart from the hurts mentioned in A to G of this section 2.4, okay, under the provisions of Indian Penal Code, grievous hurt would include fracture or dislocation of the bone or tooth. That is also included there in Indian Penal Code in section 320. And so also any hurt which causes the sufferer to be during the space of 20 days in severe bodily pain or unable to follow his ordinary pursuits, that also gets included there in Indian Penal Code. So that is a slight difference between the definition as given in Indian Penal Code and as given in this Parsi Act as such. Then you move on to this definition of Parsi. So these are PERS, PERS, or FARS, FARS, FARS. I don't know whether I'm getting the pronunciation right. I'm not a Parsi. But then as far as I can understand, it could be pronounced as PERS or FARS. No? They are FARS. This is a province in Persia as such. So the Parsi, as defined in section 2.7 of this, as Parsi Zoroastrian. No? Zoroastrian would be a person who professes the Zoroastrian faith, need not necessarily be a Parsi. The word Parsi is only a kind of uh, racial connotation, and it has nothing to do whatsoever with the religious profession as such. And this word takes its derivation from the word, as I said, Pers or Fars, which are provinces in Persia, from which the original Persian emigrants they came to India as such. So from the province of Pers or Fars, they have come to India, and who are born Zoroastrian parents and who profess the Zoroastrian religion also. Okay, so let me say this again. This word Parsi, it has only a racial connotation. It has nothing to do whatsoever with his religious professions. This word takes its derivation from Pers or Fars, a province in Persia, from which the original Persian immigrants came to India. This Parsi community would consist of Parsis who are descendants from this original Persian immigrants and who are born of this Zoroastrian parents and who profess the Zoroastrian religion. Okay, so the Iranians from Persia professing the Zoroastrian religion who came to India either temporarily or permanently, and the children of Parsi fathers, it could be by alien mothers also, foreign mothers who have been duly and properly admitted into the religion. All of them come into this. Okay. Uh, yeah. So you have a case law with regard to this. It's Dinshaw M. Petit versus Dinshaw M. Petit Sir versus Jamshedji Jijibai. Okay. Earlier, Bombay High Court, no, in its order, uh, an Iranian who was temporarily residing in India and who was registered as a foreigner and whose domicile continues to be Persian, the Honorable Bombay High Court said that he does not become a Parsi merely because he is a Zoroastrian and because he is not a Parsi. Yes. And the Parsi Marriage and Divorce Act does not apply to him. But later on, however, this view was changed and it was held that the word Parsi in the Act means Zoroastrians, both of India and of Iran. And the court constituted under this Act has jurisdiction over them. So both no, means Zoroastrian of India as well as that of Iran. Then you have these two words when it comes to the definition of priest, the Parsi priest. Okay, the two words used there are dastur and mobed. Dastur would mean a high priest and mobed would mean an ordinary priest. Though if you talk to any Parsis, they would say no, it's not about hierarchy or anything as such. But then technically, if you see some commentary, they would say Dastur is a high head priest and Mobed is a ordinary priest. Okay. Otherwise, it seems there's no difference as per what was told to me. I was fortunate to do some research into this various religious ceremonies of Parsis, but that was donkeys years ago. Okay, when I was doing some kind of uh, uh, trying to understand various faiths, no, in some uh, course that I had undertaken called interreligious dialogue. Okay, moving further, when we are talking about marriages between Parsis, Section 3 gives us what would be the requisites for validity of a Parsi marriage. And they say no marriage would be valid. So they're saying it will not be valid if they are related to each other in any of the degrees of consanguinity or affinity, which is given in the Schedule 1, or that marriage is not solemnized according to the Parsi form of ceremony called Ashirvad. Very beautifully, they call their ceremony Ashirvad. I liked it very much personally, I said. Okay, and it is done by a priest and in the presence of two Parsi witnesses other than such priest, and or not and or in the case of any Parsi, whether said Parsi has changed his or her religion or domicile or not, who if a male has not completed 21 years of age and if a female has not completed 18 years of age. So this is the requisite of a valid marriage. Now this age thing had come into it, come brought about by way of amendment in the year 1988. It was substituted for the earlier thing that was there. Then subsection 2 of this section 3 talk about there's a non-obstante clause there saying notwithstanding that the marriage is invalid under any of the provisions of subsection 1, any child of that marriage who would have been legitimate if the marriage had been valid shall be legitimate. So they are not allowing any of these things to affect the legitimacy of the child. So child continues to be a legitimate child. Okay. So moving further, we spoke about degrees of prohibited relationship. So Christianity also has something similar we said the other day. So almost all communities they prohibit or discourage marriages between certain relations through consanguinity, which would mean through blood or descent, through a common ancestor, and affinity. Affinity is by marriage. No? So these are restricted relations or other relations with whom marriages are restricted as such. Parsi law has also this prohibited degrees of consanguinity and affinity. Okay, and when it comes to the words brother and sister, it denotes brother and sister of the whole as well as half blood. Relationship by step means relationship by marriages. No? And there are relationships which fall in certain degrees. No? Man's prohibited degrees of relationship are, no? It could be relationship to father, to give one or two examples, father's mother, father's wife. No? These are man's prohibited degree of relationship as far as relationship to father are concerned. When it comes to relationship to mother, it is one or two examples would be mother's mother. It could be mother's mother. No? There's again a relationship through mother as such. When it comes to relationship to son, it could be son's daughter or stepson's daughter and so on. When it comes to relationship to daughter, it could be daughter or stepdaughter or any direct descendant. Okay. Comes to relationship to wife, it could be wife's mother or stepmother. It could be wife's father's sister and so on. Comes to relationship to sister, it's sister or stepsister, or it could be sister, son's wife, and so on. Comes to relationship to brother, to brothers, daughters, or stepbrothers, daughters, or any of direct lineal descendant of a brother, or stepbrother, or brother's son's wife, and so on. If it is wife, when it comes to wife's prohibited degree of relationship to father could be father or stepbrother, father or stepfather. It could be father's father. Comes to relationship to mother, it could be mother's father, mother's father, and so on. So, or when it comes to relationship to brother, it's brother or stepbrother. When it comes to relationship to sister, it could be sister's daughter's husband. Comes to relationship to son or stepson or any direct lineage lineal descendant of either. So, and last few others, relationship to daughter. It could be daughter's son or stepdaughter's son and so on. Comes to relationship to husband, husband's father or stepfather, husband father's father's father, and so on. Okay. So these are the various relationships given in the schedule as such. Then when we talk about Ashirvad, I believe perhaps the only question which was asked was on Ashirvad as such, which is what their marriages are called. Ashirvad literally mean, as we may be quite familiar with, it means blessings. No, you're invoking the uh, it is invocation of the divinity, no, to bless the marital ties. Many religions believe this. Okay, and it is performed by a priest, a man of Parsi religion. I remember one of my students, she had two of her children and she had sent both her children to the Parsi seminary. And I'm staying pretty close to that Parsi seminary and where the children were studying then. That time I was teaching somewhere in Alpesh Modi in the Mumbai University Kalina campus. And she was so proud of sending her children because she knew that she would get the best of education. And then later on, they were free to pursue whatever their career they chose to. Okay. I had also fortunate to interact with some Parsi priest, okay, whom we had called for some interfaith dialogue that we had organized on a couple of occasions. And he was kind enough to uh, uh, accept our invitation and address the gathering. It was very nice to hear about their faith on certain aspects, no? The topics that we had chosen there. Coming back to this word Ashirvad, as I said, it means blessing, and you're invoking the blessings of the divinity for that marital tie. And I already said this Mobed means ordinary priest, and Dastur means head priest. The Ashirvad may be performed by any one of them. That is why Parsi would say they're all the same. There's no hierarchy, as in Christianity, you would have a priest only giving certain sacraments, and you would have a higher level, higher than the priest, a bishop. He would give a sacrament called confirmation. Not all priestly class would give all the sacraments. But that distinction doesn't seem to be made here. Now, just for a case law, if you wish to, Menka Gandhi versus Indira Gandhi, uh, in this reported case, it is said that the marriage between Firoz Gandhi and Indira Gandhi was celebrated by Vedic rites. And it was therefore not a Parsi marriage. And both were Hindus, although Firoz was a Parsi by birth, it seems. Now, when it comes to age, we have seen that the amendment was brought about in the year 1988. I told you 21 for male and 18 for the females. Before the amendment, things were different. One had to obtain the consent of the uh, his or her father or guardian, and all of that was there before 1988. This is just of academic interest. Okay. Then when you uh, moving on further, we go on to section 4, where they talk about remarriage when unlawful. So the section is run into several lines. It says no Parsi, whether said Parsi changes or her religion or domicile, no, shall contract any marriage under this act or any other law in the lifetime of his or her wife or husband, whether a Parsi or not, except after his or her lawful divorce from such wife or husband, after his or her marriage with such wife or husband has lawfully been declared null and void or dissolved, and if the marriage was contracted with such wife or husband under the Parsi Marriage and Divorce Act 1865 or under this act, that is the present 1936, except after a divorce, declaration or dissolution as aforesaid under either of the said acts. And subsection 2 of section 4 will say every marriage contracted contrary to the provisions of subsection 1 shall be void. So, yeah. Now, there's this monogamy for Parsis. Okay. Parsi Marriage and Divorce Act 1865. It for the first time provided monogamy within the meaning of section 494 and 495 of IPC for the Parsis. That act was not retrospective. Hence, bigamous marriages contracted before 1865, they were exempted from any penal consequences as they were not unlawful. Not unlawful. Okay. Uh, then moving on to another, what about the legal status of a bigamous marriage? Section 4, subsection 2 lays down categorical, in very clear words, categorical language. The marriage in contravention of those restrictions given there is void, and it means void. And further on, you can add some Latin phrase to it saying, Non est ab initio. Non est, as if it did not exist at all. No, nothing in the eyes of law. Okay. Non-existent from the very beginning. That is what it amounts to. Then you have punishment for bigamy. You have 7 years plus fine. You have 10 years plus fine, as given in that section 5. Okay. So it is subject to the penalties given in 494, 495 of IPC. Okay. So I'm not taking you all to the whole of that section. It consumes a lot of time, and I don't wish to hold you all back for a long time. Now, if it is attempt to commit bigamy, the Honorable Supreme Court has held a number of cases that the offense of bigamy under Section 494 is committed when the necessary ceremonies of marriages are celebrated in due form in both marriages. Ceremonies are important. I remember, though not directly connected with this, in another case where the ceremonies were not properly performed, then the marriage goes for a toss. It is no marriage in the eyes of law, which we know very well. Now, in one of the matters called Sabir Kumar Kundu was the state of Bengal, this question came up before the division bench of Honorable Calcutta High Court, and whether or not a person who having intended or made preparation to contract a bigamous marriage, would he be punishable for attempt to commit bigamy, even though all the requisite ceremonies like your viva, uh, homa, or saptapadi, or they were not affirmatively proved to have been performed, and the offense of bigamy, whether it is committed or not, court said no, no offense of bigamy is complete in this case because those uh, rites, rituals, what have we performed, what has to be performed, those were not performed as such. Moving on, sorry. So we have already seen that one cannot be convicted for attempt to commit bigamy under Section 494, read with 511 of the IPC as such. Now, these sections of IPC, they do not apply as such as, no, and there's the Latin phrase called ex proprio vigore, ex proprio vigore, which means of or by its own force independently. They don't apply by itself. No, something like suo motu, they don't apply. Ex proprio vigore. This is a rule of interpretation which is enshrined in that maxim, okay, which is generally a specialibus non derogant or generally bus specially a derogant, that a special law prevails over the general law. That is the understanding meaning of that Latin maxims. So special law will prevail over the general law covering the same subject. And this Parsi Marriage and Divorce Act, it does not incorporate Section 511 of IPC, no, that attempt and all that. Therefore, a person who attempted to commit bigamy can neither be convicted nor punished in the absence of enabling provisions in the Act. No? So, yeah. And then we move on to Section 6. It's about certificate and registry of marriage. Okay. So, it has to be certified by officiating priest, the form contained in Schedule 2. Okay. Then the certificate would have to be signed by the priest and the contracting parties and two witnesses. And the priest would thereupon send such certificate with a fee of 2 rupees to be paid by husband to the registrar of the place. So they very clearly say who has to pay that fees also. Okay, not because there could be a dispute on that, but it's clear on who's got to pay. Okay. Then the registrar, when he receives that certificate and the fee, he would enter it in the certificate, enter the certificate in the register to be kept by him for the purpose, and shall be entitled to retain the fee as such. Uh, Now, this certificate which is required to be given by the officiating priest, that is not in itself one of the requisites for a valid marriage amongst the Parsis. That we have to keep in mind. Nor is an entry in the register maintained according to section 6 to 12. No, they are not requisites of valid marriage. Then you have section 17, which will talk about marriage is not considered invalid because merely because the provision of section 6 are not complied with. No, where there is no certificate and no entry in the marriage register and any other relevant evidence is admissible as proof of the marriage having taken place, that is good enough. Okay. So, yeah, this you will have in Bhai Avabai versus Kodadad Ardeshir Kocha BOG. No? So, I'm not repeating it. If necessary, during an interview time, you all will need all of this. We say during that time. Moving on, or I may post it in the group if required. Then you have section 7, which is appointment of registrar, who appoints the chief justice of the court, of such court, and without outside the limits also by the state government, outside the limit. Every registrar would be appointed. It can be removed by the chief justice or the state government appointing him. Then you have section 8, talks about marriage registrar. It will be kept open for public inspection as such. Okay. So at all reasonable times, it will be open for inspection, and certified extracts would have to be given by the registrar on payment to him of ₹2 fees, and every register shall be evidence of truth of the statements therein contained. Then you have section 9. Most of such marriage and divorce act will have this uh, procedural things also given there. Okay, which is normally left in other legislation to your rules and such things. Then section 9, copy of that certificate to be sent to the Registrar General of Births, Deaths and Marriages. So that is provided in this section 9 as such. And what interval the state government said, what intervals it has to be sent to the Registrar General of Births, Deaths and Marriage for the territories administered by such state governments as such. Okay, and you would have to send it as a true copy certified by him. Then you have section 10 talking about registration of divorces. Now, when the court passes a decree for divorce, nullity or dissolution, court would have to send a copy of the decree for registration to the registrar of marriages, and that registrar would have to enter in a register to be kept by him. So all this is provided in section 10. Then you have section 11, which talks about penalty. So it's 6 months or fine, ₹200 or both. If you go to it, you'll get to know that. Then this is penalty for solemnizing marriage contrary to section 4. When you move on to section 12, it will talk about penalty for priest's neglect of requirement of section 6. So there it is, it will extend to 3 months or with fine, which may extend to ₹1,000 or with both. Then you move on to section 13, which will talk about penalty for omitting to subscribe an attest certificate. There the punishment for every such offense is fine not exceeding ₹1,000. Then you have penalty for making false certificates, okay, and other things. You have simple imprisonment for a term which may extend to 3 months, or with fine which may extend to ₹1,000 or both, okay. And if the act amounts to forgery as defined in IPC, then that person would also be liable to the penalties provided in section 466, 7 years of fine, forgery of the records of court or a public register. It's about all that. Then you move on to section 15, which is about penalty for failing to register certificate. It's 1 year or with fine or which may extend to ₹1,000 or with both. Then you have section 16, which talks about penalty for secreting, destroying or altering register. There the penalty is extended, it could be extended up to 2 years. So it will say any person secreting, destroying or dishonestly or fraudulently altering the said register any part thereof, punished with imprisonment for either description defined in IPC for a term which may extend to 2 years, or if he be a registrar, then which may extend to 5 years. So that slight difference is there. And also be liable to fine which may extend to ₹500. During the Corona days, when you're required to set a whole lot of objective kind of question papers, we would ask such details also. No? So somewhere it is 2 years. If it committed by a registrar, then 5 years. So that difference, wherever such things are there, perhaps you'll take a good note of it so that you don't lose out on that single mark as well, which a mark or two, whatever may be assigned to this subject. Then you have section 17, which will talk about formal irregularity not to invalidate marriage. The title says it all, the headnote says it all. So no marriage contracted under this act shall be deemed to be invalid solely by the reason of the fact that it was not certified under section 6, which I have already seen, or that the certificate was not sent to the register, or that the certificate was defective, irregular, or incorrect. And rightly so, I think a lot of wisdom which goes into framing such section. Then you have section 18, which talks about constitutional or special courts under this act. So for the purpose of hearing suits under this act, special court would have to be constituted under each presidency towns of Calcutta, Madras, and Bombay, and in other places in the territories of the several state governments, as such governments would respectively think fit. Then you have Parsi chief matrimonial courts as such. So the courts so constitute each of the presidency towns will be entitled there shall be entitled the Parsi Chief Metropolitan Court of Calcutta, Madras, or Bombay, as the case may be. Then the local limits of the jurisdiction of this PCMC will say Parsi Chief Metropolitan Court shall be coterminous with the local limits of the ordinary original civil jurisdiction of the High Court. Coterminous, whatever jurisdiction you have the Honorable High Court, ordinary original civil jurisdiction, same will be the jurisdiction for this Parsi Chief Metropolitan Matrimonial Court. I'm sorry, Matrimonial Court. Chief Justice of the High Court or such other judge of the High Court or the Chief Justice from time to time appoint shall be the judge of such matrimonial court. In case trial of cases under this act, he shall be aided, assisted by 5 delegates. So a little while ago, initially itself we said court, no court, number of sections that we said court would mean only the judge alone and all of that. So here we have come across in section 19 that court is also assisted, aided by 5 delegates, just as, yeah, except in regard to if it's an interlocutory application and proceeding, or if it's an alimony and maintenance, both permanent as well as pending litigation, okay, or custody, maintenance, education of children, and all matters and proceedings other than the regular hearing of cases, okay. Other than, if it is this, then it is only the judge who will preside, okay. So otherwise it would be the judge as well as those 5 delegates. Then you have, so this also section from this angle could be important. Anything will be asked from any nook and corner. So just kind of, I felt this perhaps could be important, but we never know what could be asked from where. Section 20, you have Parsi district matrimonial courts. No? Every court so constituted at any place other than a presidency town, they'll be entitled Parsi district matrimonial court, PDMC. Earlier it was PCMC. This is PDMC. I'm just giving it some abbreviation. It is subject to provisions contained in section 21, and the local limits of the jurisdiction of that court would be again court terminus with the district in which it is held. No? And the judge of the principal court of ordinary civil jurisdiction at such place, he would be the judge of this matrimonial court, and in trial of cases under this act, be aided by 5 delegates again. So here also 5 delegates in case that number is asked. I'm not so much, impressed by people asking these numbers and how much is the amount of penalty and the year. Of course, it's always good to know, but that could be just a memory test. Okay, something which would test your cognitive skills or any such thing, which will really make you think before answering. That would be more appreciated. But anyway, I don't dictate or I don't decide how the question paper is going to be. You already have some precedents. You'll have to go by that. I have pulled out some hard copies of the question paper sent to me, but I hardly find any question on Parsi Act. There are, but not as many as you would have on other laws as such. Okay. Then we move further. We have covered section 20 as such. Then uh, principal judge of the matrimonial courts, you would have to be aided by delegates only when the matters are contested as such. In a case of divorce by mutual consent, there is no adjudication within the meaning of the section 19 or 24. Adjudication, the judicial mind is not applied to see who's right, who's wrong, merits of the case, all that is not gone into. Therefore, the principal judge there may not need the aid of the delegates as such. Okay. Then also, at the time of verdict, whether all the delegates are required to be present. One of the case laws called Pistonji, Kekuban, Barucha versus Mrs. Alu. So, in that case, it was held that not mandatory, it is not a mandatory requirement that all the delegates need to be present at the time of verdict. Then you have section 21, which talks about power to alter territorial jurisdiction of district courts. So very simple section. State government can from time to time alter the local limits, jurisdiction of any Parsi district matrimonial court, and may include within those limits any number of districts under its government. Then you have section 22, which talks about certain districts to be within jurisdiction of chief matrimonial courts. Okay, any district with the state government on account of the fewness of its Parsi inhabitants, the few in number, which we know very well, that shall be deemed it inexpedient to include within the jurisdiction of any district matrimonial court, shall be included within the jurisdiction of the Parsi chief matrimonial court for the territories under such state government where there is such court. So if there are few Parsis, then the court will be this Parsi Chief Metropolitan Matrimonial Court as such. Then you have section 23, court's seal. No seal would be made for every court constituted under this act, and all decrees and orders and copies of decrees and orders of this court be sealed with that seal, and that would have to be kept in the custody of the presiding judge as such. Then you have appointment of delegates, which is in 24. State government in the presidency towns and districts, subject to respective governments. They can appoint person to be delegates to aid in the adjudication of cases. Delegates are required in the adjudication of cases, just as you had the jury system, somewhat similar to that, and arising under this act, after giving the local parties an opportunity of expressing their opinion, such manner as the respective governments may think fit. So the views, opinions of the local parties are taken into consideration. A beautiful provision where the delegates are, in a way, they are representatives, kind of, or somebody whom they acknowledge, recognize as such. Then 24 subsection 2 talks about the persons who appointed has to be a Parsi, unlike some trust, I'm told, where I had one matter where the trustee is a Hindu trust and they were not Hindus as such, and they had a problem with that. So here it has to be a Parsi, and the names would have to be published in the Gazette, and the number within the local limits of the ordinary original civil jurisdiction of the High Court, not more than 30. And the districts beyond such limits, not more than 20 as such. All these are technical, figures which I don't know whether you should remember from the examination point of view that you have to take a call. Then you have power to appoint new delegates also. No? So appointment of delegates would be for 10 years, and you'll be eligible for reappointment for a like term. That means another 10 years. Whenever a delegate would die or has completed his term of office, or if he desires to relinquish his office or refuses or becomes incapable, unfit to act, or ceases to be a Parsi, or gets convicted under IPC or any other law for time before involving moral turpitude, or is a judge insolvent, then and so often the state government may appoint any person being a Parsi to be delegate in his stead. Uske jagah pe, this new person will be appointed, and the name of that person would have to be published in the Gazette as well. Okay. So this is right up to section 25. Okay. So then you move on to section 26, which talks about delegates to be deemed public servant. So that definition, section 21 of IPC is so very important. It defines public servant. So delegates appointed under this act considered to public servant within the meaning of Indian Penal Code as such. Then you have section 27, selection of delegates under section 19 and 20. From those appointed under section 24, there's provision with regard to that. It talks about under the orders of the presiding judge of the court in due rotation from the delegates will be appointed by the state government under section 24. And there's a proviso which says that each party to the suit may without cause assign, challenge any two of the delegates attending the court before such delegates are selected, and no delegate so challenged shall be selected. So, like of late, you have provision in arbitration and all that, and all the case laws which had happened before the various amendments. All those case laws have found their way in the schedule and in the act itself, where person interest is involved or where there is some prejudice and all of that, or he should not be appointed as arbitrator. There's an objection to it. Something similar already existed way back, and here the provision is such that the proviso is important of the section 27 from the understanding point of view, says that every party to the suit may without cause assign, need not give any reason, challenge any two of the delegates. Once they challenge it, then they cannot be delegates as such. That is the short point that I wanted to bring to your notice. No? So challenge to that assignment is to be exercised before the trial begins, not afterwards. No? That is what the Honorable Bombay High Court has said, that a delegate under the Act is in a similar position to kind of a juryman, and you cannot challenge it in the appeal as such. Most of the laws you'll find you always have to challenge anything first in point of time at the earliest opportunity and so on. Then you have, as far as practitioners in matrimonial courts, section 28, all legal practitioners are entitled to practice in High Court. They are entitled to practice in any court constituted under this Act. And legal practitioners entitled to practice in district court will be entitled to practice in any Parsi district matrimonial courts. So that entitlement is very clearly given who can practice. All. And they are not restricting it to only Parsi advocates or any such thing, if at all there is any misconception. Then you have section 29, talks about court in which suit to be brought. Okay. So all suits instituted under this act shall be brought in the court within the limits of the jurisdiction the defendant resides. All civil matters you will see mostly it is that way. Defendant resides. Of course, there are other provisions also, depending on whether it's movable property, immovable property, so on. Jurisdictional thing is dealt with section 9 CPC and all. So at the time of institution of the suit, whether defendant resides or when the marriage under this act was solemnized, that becomes important. If the defendant has left the territories of which this act extends, then the plaintiff and the defendant last resided together. That becomes the court where the suit is required to be brought. In case whether the defendant resides in the territory which this act extends or not, such suit may be brought in the court at the place where the plaintiff resides, or in the place where the plaintiff and the defendant last resided together. Such court, after recording his reason in writing, it has to grant leave so to do. Leave would mean permission as such. Okay. If you have to get revocation of that leave granted under section 29(3), just now what we spoke about, remedy is only by way of appeal under 47(b) from the order granting leave as such. That was held so in one of the case law. I'm not giving you all the titles. Then residence, what do we mean by residence? It will depend on the circumstances. No? It is enough if it is bona fide, no? With an element of continuity about it. No? So that even if it is not permanent, it cannot be said to be merely casual or for a temporary or passing purpose. So need not be such that person should be there forever and all of that. So bona fidely is there and he has that element of continuity there. That should be good enough. Okay. Then you move on to section 30, which talks about suits for nullity. To any case where consummation of the marriage is from natural causes impossible, then such marriage may, at the instance of either party, then declared to be null and void. Very good provision, clear-cut provision. So this Parsi marriage, as we have seen, it classifies marriages in three classes. No, one is valid marriage, other is invalid marriage, and the third is void marriage. This is as far as the Parsi Marriage and Divorce Act is concerned. And we have said consummation of marriage requires an act of sexual relationship which is natural and complete. That comes across to some case law. Then moving on to section 31, you will find suits for dissolution. There the if a husband and a wife they are continually absent from his or wife or her wife or husband for the space of 7 years, not heard about or being alive within that time by persons who would have naturally heard of him or her had he or she been alive, then the marriage of that husband or wife may at the instance of either party be dissolved. Okay. So you have section 108 of Evidence Act also, 1872, with the disappearance or absence of a person for 7 years that raises a presumption of death if he has not been heard of as being alive within the period by those who would have heard of him. I was fortunate to be given an opportunity by Bar Council a couple of years ago to address the would-be judges on this evidence law, and I covered the whole of it. So I'm grateful to them for that as well. I was just reminded about it. That crossed my mind. I said I'll just express my thanks for that as well, belatedly though. Okay. Then there's as we said, so this becomes a ground for divorce, we said. Now, so this long absence is a ground for divorce under 13(1)(7) as such of the Hindu Marriage Act also, and under section 27(1)(b) of Special Marriage Act also. So similar provision is there as here as well. But under this act, it has been worded as a ground for dissolution of Parsi marriage and not of divorce under this act. So it raises a question whether there's a difference between dissolution of marriage and a divorce. What is the answer? Ultimate answer, if at all you are getting confused. Ultimate answer is no, there is no difference. So difficult to say whether there is in fact substantive difference between divorce and dissolution of marriage. And if so, what? That is would be the conclusion as such. So if you go by Chambers' 21st Century Dictionary, dissolution means the ending of a formal or legal partnership, that is marriage, or divorce means legal ending of a marriage, and there seems to be no practical difference between the two concepts. Again, in this act, the heading of section 32b is divorce by mutual consent, and the suit to be filed under section 32b(1) is called suit for divorce. But 32b(1) suit is called suit for divorce. But the decree to be passed under section 32B(2) is called decree declaring the marriage to be dissolved as such. Decree declaring the marriage to be dissolved as such. Can you take a note of this? Then you have section 32. There are numerous grounds given there for divorce. Any married person may sue for divorce on any, it says, on any one or more of the following ground. Number of things are there. Marriage not consummated within 1 year. Okay. Defendant was of unsound mind, habitually so up to the date of suit. There's a proviso to that. No, the plaintiff, if he was not ignorant about it, then that's a different thing. And he has filed a suit within 3 years. Then BB talks about incurably of unsound mind for a period of 2 years or upwards, or continuously intermittently suffers from mental disorder of such kind, and to such an extent that the plaintiff cannot reasonably be expressed to live with the defendant. Then you have certain terms given, explained in the explanation. One is mental disorder, how they want us to understand mental disorder means mental illness, arrested or incomplete development of mind, uh, psychopathic disorder or any other disorder or disability of mind, includes schizophrenia also. Then psychopathic disorder would mean persistent disorder or disability of mind, whether or not including such subnormality of intelligence, no, which results in abnormally aggressive or seriously irresponsible conduct on the part of the defendant, whether or not it requires or is susceptible to medical treatment, irrespective of that. Then another ground could be defendant was at the time of marriage pregnant by some person other than the plaintiff, and provided divorce shall not be granted on this ground unless plaintiff at the time of marriage was ignorant of this fact and the suit has been filed within 2 years. Again, D would tell you about adultery or fornication or bigamy or rape, and there's a proviso, divorce may be granted on this ground where the suit is filed not has been filed more than 2 years after the plaintiff came to know about it. Should be filed after more than 2 years. Next one, double D, incorporated later on. Will tell you about cruelty. Okay. So defendant has since the solemnization of marriage treated the plaintiff with cruelty or has behaved in such a way, render it in the judgment of the court improper to compel the plaintiff to live with the defendant. And like this, improper to compel. You cannot compel anybody. There's conjugal rights and all that is apparently seems to be kind of compilation, but eventually it leads to the such separation and all. Now, there's a proviso to this. Every suit for divorce on this ground, it shall be in the discretion of the court. It should grant a decree for divorce or for judicial separation. Then the defendant has in the marriage voluntarily caused grievous hurt to the plaintiff, or infected the plaintiff with venereal disease, or where the defendant is the husband has compelled the wife to submit herself to prostitution, the proviso to is okay. So suit should not be filed after more than 2 years, and after the infliction of the grievous hurt, after the plaintiff came to know of the infection, or after the last act of compulsory prostitution. Then you have defendant is undergoing a sentence of imprisonment for 7 years or more for an offense under IPC. There's a proviso again under the defendant is prior to the filing of the suit undergone at least 1 year's imprisonment after the set period, or if the defendant had deserted the plaintiff for at least 2 years, all this become ground of divorce. Then you have order in passed by against the defendant by magistrate awarding separate maintenance to the plaintiff when the parties have not had marital intercourse for 1 year or more since such decree or order. Then you have defendant that ceased to be a Parsi by conversion to another religion. Okay, this you find in so many personal laws. Then you have provided that divorce would not be granted on that ground. Suit is filed more than 2 years after the plaintiff came to know of the fact. So these are the various grounds given. Technically, it runs up to J, but you have double D there and you have double B there. So two more to add it to J, no? But somewhere incorporated in the middle. So we have already seen, if I go into too many details of all this, it consume a lot of time. So willful refusal of consummation, we have seen 32A, we have seen unsoundness of mind, 32B, no? So that application for divorce would have to be accompanied by an application for a direction for medical examination of respondent. Then the power of matrimonial code extends to issuance of that direction also. There are such case laws under various grounds of divorce as such. No? So what is fornication? We came across that word adultery. fornication, bigamy, and all of that. Fornication will be illicit sexual intercourse either between a married man and an unmarried woman, or between a married woman and an unmarried man, and is a good ground for divorce satisfaction. Okay. Then you have cruelty. The other day, I believe somebody spoke on cruelty under various personal laws. That resource person must have covered a lot of ground on cruelty, I guess. So cruelty is given in 32 double D by the amendment of 1988. Okay, legal sin need not necessarily be physical violence to the husband or to the wife. It could be to both. It could be harsh conduct, no, pursued by the husband towards his wife and or their children, and also vice versa by the wife. Even a single act, if it is gross cruelty, that may be enough to constitute legal cruelty. Okay. With this, I'm not going into too many details, because it's many times also just in the passing. Many times it's difficult to really adjudicate where the blame lies, who is at fault. uh. But one has to be satisfied that the causes of disagreement are grave and weighty and such to an absolute, that is moral impossibility that the duties of married life can be discharged. And determining what is moral impossibility, case law says, uh, it's pointed out by Justice Fulton in Hirabai versus Dhananji. They would take into consideration the feelings and customs of the Parsi community. So very important. No? Every community has a sense of feeling, sense of custom, and they would have to bear in mind the grave responsibility that would rest on them. No? So if you ignore all these things, then you will not be doing justice. You will not uphold the sanctity of a married life. No? So you have to balance all this. Okay. So you cannot come to some barbarous results as such. And you cannot compel a husband and or a wife to live together. Living together as such becomes morally impossible, it is said. Okay. Then uh, there are other grounds, mental cruelty. If you are repeating causing embarrassment in social situation, that can also amount to uh, uh, what we say cruelty as such, and that is Parveen Mehta versus Inderjit Mehta, somewhere in 2002. Repeatedly causing embarrassment in social situation can amount to mental cruelty. Some advocates have to just know that there are some such case laws, and they will find a way of incorporating all this in their litigation, whether it is arising out of the facts of that case or not, which is, I guess, not in keeping with professional ethics. But so much for moralizing. Grievous that I've already commented. No, cruelty has been made a ground for divorce by Parsi Divorce and Parsi Marriage and Divorce Amendment Act 1988. Okay. Then venereal disease also we know, prostitution also we know as in, that could be a ground as such, from 2 years from the date of knowledge itself. Then you have long imprisonment. No? So here there's a slight distinction. Okay. Where spouse is imprisoned for 7 years or more, the life of the other spouse will become abnormal. And if that spouse wishes to break the marital tie with prisoner so that he or she may start a new life, this provision in 32F, this provision would facilitate that to happen, him or her, by obtaining divorce on this ground. Similar provision is there in the Special Marriage Act 1954 and the Dissolution of Muslim Marriage Act 1939. But this provision is absent in Hindu Marriage Act 1955 and the Divorce Act, Indian Divorce Act 1869. So a slight difference there with regard to personal laws. That is where I believe this Uniform Civil Code may uh, come in, or other one of the reasons perhaps to put an end to this discriminatory thing as viewed from the perspective of one who gets aggrieved. Then you have the ground of desertion as well. Desertion should have been lasted for 2 or more years. All those things are there. So if the person is confined in lunatic asylum, if at all, then that is not to be taken into consideration in computing those 2 years. One of the case laws would say that. No? So I'm trying to go as fast as possible. Uh, Sometimes a mere doubt when it comes to one of the grounds saying conversion of religion and all that. So mere doubt that Parsi has changed his religion, that's not a suspicion or a mere doubt is not good enough. One of the case laws would say. No, obviously so. Okay, but the courts had to tell them it's Dunbai Palkiwala versus Saurabhji Palkiwala. That case law it was said. So somebody was alleging that he is converted to some other religion, the burden would lie on that person. Then you have 32A, non-resumption of cohabitation or restitution of conjugal rights within 1 year, pursuance of the decree to be ground for divorce. That also would be a ground for divorce. Person can sue for divorce also on that ground that there are no resumption of cohabitation. Okay, so uh, for 1 year or upwards after the passing of decree of judicial separation, and that there has been no restitution of conjugal rights for a period of 1 year or upwards. And subsequently, we'll talk about no decree for divorce would be granted on the one if the plaintiff has failed or neglected to comply with the order for maintenance passed against him under Section 40 of this Act or Section 488 of the CRPC. Okay, so 488 is the magistrate is satisfied wife is entitled to maintenance. So that's old CRPC. Then or Section 125 of CRPC, which is about maintaining parents and all of it. Then you have moving on. Then you have 32B, divorce by mutual consent. Okay, so it's saying subject to the provision of the Act. Obviously, it's filed by both the parties to marry together, whether that marriage was solemn before or after the commencement. So apply retrospectively, prospectively also, and uh, after the Parsi Marriage and Divorce Amendment Act 1988. On the ground, what would be the ground that they have been living separately for a period of 1 year or more? They have not been living together, and they have mutually agreed that marriage should be dissolved. No suit would be filed unless at the date of filing of the suit, 1 year has elapsed since the date of the marriage. So that 1 year should have elapsed. Then subsection 2 will talk about marriage, which is solemnized under the Act, and our means the plaint or true contents of either party the suit was not obtained by force, fraud, then a decree would be passed declaring the marriage to be dissolved. So all these averment. So the law itself tells you it is as if what is how the drafting is to be done is given in the law itself, and what are mandatory requirements to be mentioned in the uh, uh, mutual consent mentioned in this divorce by mutual consent draft as such. Then you have joining of co-defendants in every suit for divorce on the ground of adultery. So plaintiff would, unless the court tells otherwise, make the person with whom the adultery is alleged to have been committed a co-defendant, and in such suit by the husband, the court may order the adulterer to pay the whole or any part of the cost of the proceedings. So adulterer to pay. No? So uh, even before that, a small comment on the difference between special marriage and Hindu Marriage Act. Now, special marriage and Hindu Marriage Act, it also makes a provision for divorce by mutual consent. No? And but there is significant difference, it seems. Under this act, the court starts its proceeding immediately on receiving the application. But under those acts, there is 6 months waiting period. Only when the parties make a joint move after 6 months, but not later than 18 months from the date of the submission of the petition, court will proceed with the case. Okay. So that is one thing to be noted as such. In one of the cases called Pankaj Parmar versus Shikha Parmar, under Section 13B of the Hindu Marriage Act, it was held that the period of 18 months is not the limitation period, and so the second motion of this period is not barred as such. Then I just spoke about adulterer to pay in Section 33. I'm moving ahead, okay, to Section 34, which is suits for judicial separation. Married person may sue for judicial separation. Any of the grounds which such person could have filed for divorce. Okay, so those grounds are available to. Then you have decrease in certain suits. So suits, be it under 30, 31, 32, 32A, 34, defendant or not, the court is satisfied. Any of the grounds set forth in those sections for granting relief exist, that none of the ground therein setting forth for withholding relief exists, and that the act or omission set forth in the plaint has not been condoned, husband or wife are not colluding together, plaintiff has not connived or has been accessory to the said act or omission, where except where the definite period of limitation provided by the act, there has been no unnecessary or improper delay in instituting the suit, and there is no other legal ground why relief should not be granted. No? So then in such cases, but not otherwise, the court will decree that relief accordingly, it says. Okay, moving on to Section 36, suits for restitution of conjugal rights, husband shall have, when husband has, where husband shall have deserted or will without lawful cause cease to cohabit with his wife, or where a wife shall have deserted or without lawful cause cease to have cohabit with the husband. Parties so deserted or with whom cohabitation shall have so ceased to may sue for restitution of his or her conjugal rights, and the court, if it is satisfied of the truth of the allegation contained in the plaint, and if the court feels there is no just ground why relief should not be granted, it can proceed to decree such restitution of conjugal rights as such. Okay. Now, question as to what will be lawful or just cause for refusal to cohabit, it's a question of fact to be determined by the delegates. And the ground for refusal to cohabit, those grounds should be grave and weighty, carrying weight, and such as to make the due performance of mutual obligation morally impossible. This was held in one of the cases called Hirabai versus Dhanjibai as such. Then you have counterclaim by defendant for any relief. So in any suit under this act, defendant may make a counterclaim for any relief by or relief he or she may be entitled to under this act. So counterclaim is also possible, as you have in this written statement in CPC. Okay, order 8, I believe. 6 is pleading, 7 is plaint, it is written statement. Written statement would be not only the counter, to your plaint, but also your claiming set off could be if it is entitled to, or counterclaim also. All that become part of it. Then you have 38 talking about documentary evidence. Okay, it's a no document would be inadmissible in evidence any of the proceedings at the trial of a suit under this act on the ground that it is not duly stamped or registered. A unique provision which is not available in so many other laws. Okay, so this was brought about in 1988. So the requirements of certain law has been given a bygo under this law. So irrespective, there's a non-obstante clause. So this section overrides any other section in any other law. So it need not be stamped, need not be registered. The document. So either two, otherwise inadmissible becomes admissible. Then you have alimony pendenti lite. Pendenti lite would mean pending litigation. So if there is, it could be husband or wife as the case may be. He has no independent income sufficient for his or her support. And then the application of the husband and wife, that they can order the defendant to pay to the plaintiff the expenses of the suit and such weekly or monthly sum during the suit as having regard to the plaintiff's own income and the income of the defendant may seem to the court to be reasonable. There's a proviso, the 60 days that has to be disposed of, date of service of notice on the wife or the husband. So what should be looked at when granting such pending lite alimony is provided in the section itself. Okay. So this section also was brought about by virtue of Amendment 1988. Then you have section 40 talking about permanent alimony and maintenance. Any court which is exercising jurisdiction under this act may at any time of passing in a decree or at any time subsequent thereto, application made to it for the purpose of by the wife or the husband open to both. No? So there are other things given there. Order that the defendant shall pay to the plaintiff for her or his maintenance and support such gross sum, such monthly or periodical sum for a term not exceeding the life of the plaintiff, as having regard to the defendant's own income and other property if any, okay, conduct of the parties, other circumstances, all those things will be considered. And that amount will be a charge on the movable and immovable property of the defendant. That means if it is not paid, then the movable immovable should be attached and sold as such. If there is change of circumstances, then in the instance of either party, that order could be varied, modified, rescinded. That's coming across in section 2, subsection 2. Subsection 3 will be if the court is satisfied that the party in whose favor order has been made under this section has remarried and has not remained chaste. Chaste means without having any physical relation with somebody else. And if such party is to be husband and he has had a sexual intercourse with any woman outside wedlock, it may the instance of the other party vary, modify, or rescind any of such order. So there could be a change of order when it comes to a chastity of a person, and there's a cloud with regard to it. So uh, uh, this discretion what is given to the court to decide this alimony This cannot be assigned to an arbitrator. This also is held in one of the courts. No. So, if a wife gives up future alimony, such contract does not prevent her from claiming future alimony under Section 40 itself. No? So, such a contract, even if it is made by a contract consent order between the parties, is contrary to public policy. It is called contracting out in labor language, labor laws term. You cannot contract out what is sought to be given to you by the provisions of law as such. Normal rule is to allow alimony from the date of petition, though the rule may not be adhered to. This is said in one of the case law. Then the Parsi matrimonial code has the power to grant lump sum by way of alimony, hand over or direct the handing over of money to the wife also. That is also there. Okay, provided as such. Then you have section 41, it talks about payment of alimony to wife or to a trustee.
D'Souza sir, can I
Yes.
D'Souza sir, can I interrupt and make a request to you?
Yeah, please.
This
Yes,
is
sir, go ahead.
Dr. Uday Varunjikar, Vice
Yeah, I know,
Chairman
I
of
can
Bar
recognize
Council
it.
of Maharashtra and
I can
Goa.
recognize the voice, sir. Yes.
Sir, may I request you to wind up within another 3-4 minutes, because
shall
we
do that.
have another activity
Yes.
of a Bar Council, which is for other group. I'm
Yes,
so sorry. I am encroaching
no
on
issues.
your valuable time.
Yeah.
But
No
hardly
issues.
around 3 minutes are left.
No issue.
Thank you,
No
sir.
issue.
Thank you.
No issue. I'm at the fag end of all this. So most of the provisions are nothing really which needs interpretation or great detailed explanation as such. Most of them are kind of self-explanatory. The important part was that initial part. No? So just a cursory look at all of this provision, the head notes itself will make it very clear to the candidates. So 42 talks about disposal of joint property. There are provisions with regard to that. 43 will talk about suits to be heard in camera, may not be printed or published. So that is to safeguard the privacy of person. Then your validity of a trial. So not less than 3 delegates should have attended throughout the proceeding. Otherwise, the trial will not be valid. Then your provision of CPC to apply to such suits. So very clearly it said so. No? So, and then you have determination of question of law and procedures of fact. Question of law and procedure would be determined by the presiding judge. Okay, that provision is there. Then you have appeal to High Court. So any decision, any appeal shall lie to the High Court from the decision of any court established, whether a chief matrimonial court or district matrimonial court, that is covered under section 47. Okay. Then you have 48 talking about liberty of parties to marry again. That also is a self-explanatory section as such. It would be lawful for the parties, respective parties, to marry again itself. Okay. So I think uh, uh, rather than going further and just, I'm almost at the fag end of it. Okay. You have right up to 51, 52 talking about superintendents of High Court. Obviously, such provisions would be there. Then you have this 53 is repealed as such. Nothing really important to be covered. 50 is about settlement of wife's property for benefit of children. So, if it appears to the court that the wife is entitled to any property either by possession or reversion, then the court would order that settlement as it thinks reasonable. No, so to be made of any part of said property not exceeding one half thereof for the benefit of the children. That is provision section 50. I think I should stop here because I seem to have covered you know, fairly a large chunk of this act, and most of the provisions I've got covered, I guess. So I will stop here. There is a query you're free to ask, but then I think there's another session activity to happen. So thank you very much for your patient hearing. Thank you for giving an opportunity. Thank you, sir, for all your cooperation, and the staff members made this possible. Thank you very much, all of you.
Thank you so much, sir.
Thank you.
On behalf of Bar Council of Maharashtra and Goa, I'd like to thank Advocate Prosper D'Souza, sir, for guiding us on Parsi laws. I would also like to thank Chairman, Vice Chairman, and all the members of Bar Council of Maharashtra and Goa. I would like to thank Dr. Uday Varunjikar, sir, as he is a coordinator for this lecture series. I would also like to thank all the participants for participating in this lecture series. Thank you so much. Now I would request Sharat sir to conclude the lecture. Thank you